This is Headnotes, a podcast from Whitehead Monckton. Coming up on this episode.
What we're looking to do nowadays, as much as we possibly can, is to achieve a kinder and more empathetic divorce. And it's a question of how you want to get there. You know, do you want to go on the smooth motorway or do you want to go on the really bumpy road, which will take forever and a day, and you're going to get there feeling tired and flustered? You'll get to the same place. It's just a question of how long it's going to take you and how much it's going to cost you.
All families who come to us are looking for solutions, but ideally not ones that perhaps are imposed on them.
What we're looking to talk about specifically is mediation, collaborative law work, and then the new kid on the block, so to speak, which is the one lawyer, one couple. I like the words one lawyer, one couple. I think that to me sounds what I'm trying to achieve as a single neutral lawyer. So, my name's Emma Palmer, and I am a family lawyer at Whitehead Monckton, and I'm here today with two of my fellow family lawyers at Whitehead Monckton to talk about finding better ways to separate, something that I think many of the clients that come to see us are absolutely keen on, as they should be, trying to find. Sarah, over to you. Tell us a little bit about yourself and what you practice in.
Okay, thanks Emma. So I'm Sarah Brissenden. I'm a family solicitor based in the Tenterden office at Whitehead Monckton. I've been here for 12 years now. 12 happy years.
You had to say that.
Yep. And I practice all areas of family law. Primarily though, finance on divorce. Mm-hmm. And I would like to talk to you about the collaborative process, which is, I think, a brilliant process to use.
Fantastic. Dawn, tell us a little bit about yourself.
So I'm Dawn Harrison, and I have been a practicing family lawyer in the firm for probably longer than I care to share with you.
Only marginally.
But very happy to talk today about mediation, which doesn't offer legal advice as you might think we would as a firm of lawyers. It's a little bit different from giving advice. I can only give legal information. So it's a useful add-in to the options of non-court proceedings. As you said, Emma, all families who come to us are looking for solutions, but ideally not ones that perhaps are imposed on them.
Absolutely. And today, really, what we're looking to talk about specifically is mediation, collaborative law work, and then the new kid on the block, so to speak, which is the one lawyer, one couple process. And I've recently trained to offer that, and I'm very much looking forward to doing more and more of that kind of work. So what we're looking to do nowadays, as much as we possibly can, is to achieve a kinder and more empathetic divorce. And I think there's a real enthusiasm from many of the clients that come to us to achieve that. But it's not just us, is it? It's the court as well. So I don't know if the two of you want to talk a little bit about non-court dispute resolution, or NCDR, and how the court's view has changed too. Particularly, I suppose, with mediation is where it started.
Yes. So April of last year, the court brought in some new guidance that they wanted much more focus on non-court dispute resolution. So trying to make sure couples are really thinking before they enter any court process of using the options of mediation or collaborative practice, and we'll explain more about what they are. But one of the facets as a mediator that I do, part of the work, is introducing myself to the two clients separately from a couple, spending some time with each of them to understand what the problems are, making sure I understand their problems, but also not necessarily saying, well, you're here to mediate, but to establish whether mediation is the right option, because there are others, such as the collaborative principles that Sarah will talk about, and there's others, such as arbitration, which can avoid you using court. We often use the phrase court is the last resort, but even the court offers dispute resolution within itself, but it doesn't like to do it that way if it can avoid it, because it's finding it very challenging in the current climate with lack of judicial time, etc.
And non-court dispute resolution now, or NCDR as we call it for short, is really something the court is so hot on, to the extent that if you do start a court application, you have to have gone through a process to see somebody like you for a mediation information assessment meeting, or MIAM as we call it for short. Then once you're in those proceedings, there's now a specific form that you have to fill in to say what efforts you have made. So more and more impetus coming from the court to say, no, it's not just enough to issue, you've got to have really tried to resolve this yourself.
And if you're a respondent to an application, then you'll get papers sent to you once an application has been made and you're notified. You have 7 days to say to the court, well, the applicant hasn't made enough effort at non-court processes, and they can ask the court to consider if it would actually stay their proceedings for them to actually do what they should have done in the first place. So they're trying very hard to make people think about this.
And the court process itself, I think my experience in the last few months have been, it's just awful. You know, I've had hearings, I had 3 pre-trial reviews come out of the diary for various things. No judges available. One hearing was listed before the private FDR judge. All of these things cost the clients money because they've been preparing for a hearing. They've got, their barristers booked in, and it's just so stressful for them. So if we can just avoid all of that and do one of these other processes.
And I think it's really important, isn't it, nowadays, to start off. People always assume that if you're going to go and see a lawyer, the lawyer's going to be litigious. They just want to march off to court. They just want to make as much money as they can out of
some
the client.
do.
Well, some do, yes, but not on our books.
No, not at all. Not at all.
For us, it's always about what is in the best interest of that client, what will do best for them. And certainly for me, my entire practice has been about avoiding court. I'm very proud that I've taken very few cases to final hearing in my career. Because I generally will often say to clients, it's so unstable. Every element of it is unstable. Every choice is taken away from you, including the overall result.
There's no control at all for the clients.
And particularly now, as you just flagged, with the sort of backlogs within the court system, with the lack of judicial availability, it means that you could have a case listed for tomorrow and then it gets pulled at 4:00 and you've lost all that money. So. It's a very vulnerable place to be right now, and I think as you said, Dawn, it has to be the last resort. So given that we all 3 feel the same, we're not best keen on court processes unless we absolutely have to. Then let's talk a little bit about the stuff that we love. So Sarah, tell us a little bit about the collaborative. I mean, we're both collaboratively trained, I should add.
Yeah, and Dawn is too.
And Dawn is too. I forgot. Sorry.
Yeah.
See, we're so enthusiastic about it. But I love being a collaborative lawyer. But I'm going to let you talk about it a little bit today because I'm going to talk about something different. So tell us a little bit about it. Tell the audience what it means.
So collaborative law, so one couple, you would both instruct 2 collaboratively trained solicitors, and the idea is to get around a table and have meetings, the 4 of you. And at the very start, you can sign up to the participation agreement. So you're saying that you can really invest yourself in the meeting, in the meetings, in the whole process. You also prepare an anchor statement, which can be really useful because, of course, we all know when couples are separating, they might not, they're not going to necessarily get on.
Be on what they don't agree on, whereas the anchor statement is designed to help them to focus on mutual concepts, the reasons why they're coming to the collaborative process.
Exactly, and that's sort of some things which we might have to come back to.
Tell the audience what an anchor statement might commonly have. I mean, I've seen them in my time with, what you want out of the process. And not just the collaborative law process, but of the process of being divorced and separated. What are your aims and ambitions? That's commonly what an anchor statement would include.
It's a lot more holistic than, well, I want the children. You can't have the children. They're your children. Stop squabbling over the children.
But it might contain statements like, I want to be able to look back on this process or on our divorce with dignity. I want to be able to think that we put the children first, we have to co-parent, and we want to use this process as, setting that off on the right sort of.
I want to be sitting at the children's breakfast table at their wedding, and not feel there's an awful atmosphere.
Or their 18th birthday party, something like that.
Yeah. And the use of that anchor statement is then that if the process starts to unravel a little bit, you've got something to anchor them back to the table.
Draw them back to. Let's roll back a bit to the anchor statement. So so that's really useful.
Explain a little bit about the participation agreement, because many people might not understand what that is.
So the participation agreement is something that we all sign up to.
And like a contract sort of
it's
of intention, really.
Yes, it's a contract of intention. I think probably I think it's a pro, but I suppose one sort of con to collaboration is if the process does break down, which is rare. I think.
Yeah. I've never had one break down.
No, neither have I.
I've only had the one. Sorry, ladies.
Rare, but not impossible. You would, if the process does break down, the clients would need to go and seek other firms of solicitors.
Yes, although they have introduced into the participation agreement since it was first launched a clause. You can agree to have it in or not, but I would always encourage to have it in, which allows you to say arbitration is a non-court dispute resolution option, that you can still
then stay with those
within the collaborative process.
Well, there's no
so I don't think there should ever be a reason for the participation agreement being something that, as I said, well, no, ultimately I want a judge to decide. Well, if you're of that mind, have an arbitrator then. So I don't think that really is a strong argument to say I won't try collaborative. And the other benefit of these kind of things that we're talking about rather than going to court is, particularly if you're concerned about your profile, public perception, etc., with the greater transparency in courts, you go into court, you could have a reporter wanting to be coming to your hearings. So again, keeping it within a framework that we're talking about, it's private. It's private, and it is your private information that you are sharing, whether it's about your children, whether it's about your money. Who else needs to know about it? There should be confidentiality of these things.
And that's a big change, actually, with the transparency rules. That I think people still imagine that children and financial remedy proceedings in court are private. They're not anymore.
They're certainly available to the public. Whether they would rock up and turn up to listen, etc., is another thing. But it's definitely a greater risk now, and people do need to think of these things.
So we've got our participation agreement, and hopefully everyone's signed up to it, and we've got our anchor statements. What happens next?
So unlike court proceedings where you would be given a court timetable, this is what's happening. The clients can decide, when their first meeting is, how long they want it to take, what we discuss in that meeting, what financial disclosure they want to provide. And the brilliant thing about collaboration is everything should be done in the meetings. So yes, you're paying for 2 solicitors to be there, but ideally, we do everything in those meetings. We could even draft the consent order, so you can have the whole package, and clients can see what's going on, where their money's being spent, which is brilliant for them.
And there's complete transparency because everything is shared, isn't it? All emails are done to the group of 4. Everything is hopefully done in meetings where there's agendas set. And it gives you, as a couple, that sense of complete control over your lives and the pace of your lives.
Yeah. And if we need any other experts to be involved, for example, pension experts, something we call a PODE, pension on divorce experts, if we need a report from them, we can all discuss it together. Everyone can, we can make sure that everyone understands everything. And
advice is commonly given.
Yes, to both of them
in the same room. You can sort of take time out sometimes if it helps to break things up. The lawyers can talk to each other if there's some nuance, some sensitivity before getting back into a room. So it's a very flexible system, which is why we love it so much.
Yeah, and that's a really good point, Dawn, actually. I mean, I think that doing collaborative work works best if you're working with somebody that you know and trust as another collaborative lawyer. Generally I've tended to work with 2 or 3 local lawyers that I know really well. And so we'll always have an informal chat before the meeting about, Mrs. X is a little bit sensitive about this, or Mr. X is a little bit sensitive about this. And so therefore we can pick up on that and any issues. Yeah. And then we'll always do a debrief afterwards to make sure that we've been on track and that, neither of us has been positioned in any way.
But you can do it with other people. During the pandemic, we were all working from home. And I met a very lovely collaborative lawyer from Hampshire, and we had a very successful process that we hadn't known each other before, but we made sure we had those pre-meetings and debriefs afterwards.
And that's a good point, actually, because in the pandemic we did pretty much everything we had to via Teams, Zoom, etc. But I mean, personally for me, I prefer to do collab work face-to-face. I don't know how the two of you feel about it.
Ideally, yeah.
Yeah, I think it tends to feel more empowering for everybody. Yeah. There's no place to hide kind of in that personal space. Whereas if you're in a private space, you lose some dimension, I think, perhaps. Yeah. But needs must. I
remember talking to another collab lawyer who said she did a collab in the park. In the park? Yeah, in the park. Yeah.
Picnic blanket. Yeah. That works.
Well, it was, when you could go outside and, you could meet people.
But you had to be outside.
But you had to be outside 2 meters away. So they met in the park and did a collab, which, great if you can do it. Yeah, why not?
Yeah, I've never tried that one.
No.
Brilliant. Sarah, thank you. That's really, really helpful. So what we would summarise from that is collaborative law, face-to-face process could be done via Teams or other methods. 2 lawyers working with a couple to find a resolution for them in a series of meetings. Yeah.
And sorry to interrupt, I suppose just one other point is, because the other processes we're going to talk about is, one mediator or one lawyer. I think collab would probably work best for clients who are able to, talk face to face, but potentially need a bit of support, additional support or prompting, like you say, so they have a lawyer each.
I think that's a really good point, and I think we'll come on to that in more detail at the end when we do a bit of a sort of a shop summary, but for me that would certainly be I'm not a mediator, as you know, but I'm doing the one law one couple, and I always consider whether the couple would benefit from that independent legal advice as well as being in a room together, because that's the importance of collab, isn't it? That you can have, I will always have a breakout room so that if there's points in the meeting that you need to take advice independently, you can. And obviously that isn't possible when we come on to mediation or the one lawyer. So that brings me nicely, Dawn, on to let's talk about mediation. So tell us what it is and when it's relevant and why you love it so much.
So normally what I would do as a family law mediator is I would meet with the couple in joint sessions, just as you've been talking about the collaborative, but with 4 people, so 2 lawyers, 2 clients. So there's a different dimension when I'm the only advisor in the room, although I'm not a legal advisor at that point. I'm more of a facilitator when I'm mediating. And I will have had, as I've said briefly before, I will have had separate sessions with each of them to understand what they're coming to the session with as a joint meeting, because I want to be sure, first of all, that it's actually a safe process for them and also the right process for them, because I do have this overreaching expectation on me at that first session with each of them individually to make sure I'm not putting them in a mediation process where it might not be appropriate. So what you just said just now, Sarah, the vulnerability that someone might have if they're on their own with the other person, and I'm there just to try and hold a balance and a neutrality for them so they can have open discussions. But if that doesn't feel that is safe, in inverted commas, I mean, safety is a real concern if there's been a significant abuse within the relationship, and that's a very common facet these days. We hear a lot about abusive, controlling behaviours, and I have to be very sensitive to that, as all of us do. That's one of the responsibilities that we hold, and so I can also make a decision that I don't think this couple, even if they want to mediate, I have the power to say, I don't think this is
the right option,
for you.
I think that's important, actually, because with collaborative, I have certainly done cases in collaborative, not with domestic abuse. I think that's probably a no-no for most of these processes. But where there's been a power dynamic, where perhaps the breadwinner has been in a stronger role, with collaborative, that's been okay because the lawyers in the room have been mindful of that and have managed that situation very effectively. It's one of the things we flagged and talked about, how we would deal with that. But if it's just you in the room, that's very different then, isn't it?
But don't get me wrong, I've mediated plenty of matters where there's been that sort of breadwinner, homemaker.
Yes, I didn't mean that. I mean
dynamic.
more if one person is veering into kind of slightly controlling behaviour.
Yeah. But what I look out for as a mediator is recognising that if one has more knowledge in one sphere or area, such as finance, that the other person that may have less knowledge, I'm there to support and ensure that is then shared information. It goes at a pace that is
they can
appropriate.
follow and understand.
Exactly. So sometimes being a mediator is about sitting back and just, as I say, cradling their efforts. So they do have to have enough strength of character, I suppose, and purpose to feel that this is comfortable enough for them. And it isn't for everyone, but it can be so powerful when it works really well, because when you see interplay between people, it just feels magical when they can make acknowledgements. And there needs to be a level sometimes, I think, of it can't be too raw. Going into mediation at the wrong time is ill-advised.
Yes.
So timing can be really important. They have to be, mental health needs to be stable.
Yeah.
And sometimes you might need a therapeutic person that
either
helps you.
Yes.
Yeah. So you have a therapeutic appointment, and so that you feel solid as you go through the process. Just as I recommend you go and get legal advice, because I can only give core legal information. What I don't want to do is stray into an area where I'm giving one person a sense that they're right and the other person's wrong. That's not my role at all.
No.
It helps to have legal information from my role, or be a lawyer, but there are those mediators out there that aren't, but they have to have enough sense of what's going on, because there's an awful lot in our job to look out for. There are so many complex things. And again, I would sometimes say I've handled complex mediations, but you might also say if there is a lot of complexity, maybe the collaborative approach might suit
better.
Because there's so much help that is needed, which might slow down a mediation process, because I'd normally have 2, 3, maybe even 4 sessions with them jointly, going through information sharing, then looking at what their options are, and then working with them on their options. I love the use of, in my work, I use flip charts. It's about normalising, empowering people. It's really great to see it when it works well, and you choose the right time and the right people for the process.
And then at the end of that process, what you're looking to achieve with them is as a memorandum of understanding, which explain a little bit to the audience.
So a memorandum of understanding is, as the whole mediation process is, it's what's called without prejudice. What I mean by that is no court will be told what was discussed within the mediation. They can be given the financial information that might be shared within the session, because that's factual. But in the memorandum of understanding, there'll be an open financial summary that can be separated out, but there will be a memo of everything that was discussed and what is agreed, in inverted commas, and they then take that to their lawyers, and the lawyer will then convert that into something called a consent order that they then ask the court to look over and approve, so that then there is finality over any future financial claims. Unless there's a reason that there's an ongoing level of support, then it wouldn't be a complete clean break as such at that moment. but the idea is to get as much certainty and finality for the couple. So there does have to be that dimension of lawyers. So they often come in at the beginning and at the end of the process of mediation, and they can be used within the middle as well if the advice needs to be there.
But I think across all the processes we're talking about today, that element of the without prejudice, and I think you explained that really well, Dawn, for any of the discussions that are being had. And that means you can therefore be very open, very creative, very safe, effectively, in the knowledge that what you're talking about in those processes is secret.
Yes, it's almost role-playing, illustrative of, well, if we looked at it this way, so it's hypothesising, horrible word, what would it look like if we did this? And then you can ask, well, what if, and does that work? What are the problems with that? Are there problems with that?
Reality check it.
Yeah, absolutely.
But the financial disclosure, again, the same with all of our processes, that, as you brilliantly described it, is factual, and that then could be used in a different process or even in a court process, because it's simply the facts rather than actually the kind of secret discussions that were had behind closed doors.
Nuances. To get to settlement, trying to negotiate a settlement.
Yeah, because some people will feel they can be more generous in one sphere but not in another.
But not have them held to it in another.
Excellent, thank you, Dawn. So now my turn. Yes. So the new kid on the block, as I said at the beginning, the one lawyer, one couple approach, or it's also called one lawyer, two clients, or resolution together. I like the words one lawyer, one couple. I think that, to me, sounds what I'm trying to achieve, which is working as one lawyer with a couple to hopefully resolve issues arising from their divorce and separation as a single neutral lawyer. So a bit of background to it. I mean, you'll know, but for the sake of the audience, it was pretty much prohibited for us to act for clients jointly up until the Divorce, Dissolution and Separation Act of 2020, which for the first time brought in the possibility of jointly divorcing. And I think it's fair to say on the back of that, people sort of said, well, hold on a minute, if you can get divorced jointly, well, why can't you do other things jointly? And that sort of moving forward is where we've got to now. It is heavily regulated. I mean, the difference, I think, between mediation and one law, one couple, one of the differences is that I have to be really careful of conflict because I'm giving legal advice, not just information. And so one of the first things I have to do is make sure that there isn't a conflict between the clients in terms of safeguarding issues. So very similar in a way to the MIAM that you do, that mediation, information and assessment meeting. But whereas I think you're able to act for one couple as a mediator without worrying too much about the conflict issue, I'm not, because I'm giving legal advice, and that's something the Solicitors Regulation Authority, our regulator as lawyers, was very keen for us to address. So I start off my process by having an initial meeting, which I sort of call a screening, safeguarding meeting, and we'll spend about half an hour to an hour with the couple before we move to any joint meetings, and probably doing almost exactly the same things that you're doing in that MIAM.
Sounds
Looking for power balances, looking for domestic abuse, looking for anything really that would flag a concern to me that couple could or couldn't work together jointly in a group of meetings with just me. And we did a lot of training on that when I did my training to become it, because it is easy to see in a way, isn't it? Particularly actually with one law, one couple, because with mediation, you're going to have other lawyers generally involved at some point. Yeah. But with the one law, one couple approach, you're going to just have that one lawyer. And it's a process where it is easy to see how somebody could be manipulated if there was a controlling coercive relationship, if the lawyer wasn't mindful of that dynamic, because there isn't anyone else other than the three of you. No. That's the whole point of that process.
And if someone has been, controlling in the relationship for maybe this marriage of 20 years or, however long, if they're used to being in control, they'll probably try and control the lawyer as well, control the whole process. So
I'd like to see them try it, Sarah.
Yeah, I know. Could you imagine?
But sometimes the person that isn't as, who is being controlled, doesn't even appreciate how much that control is impacting them, which is why our safeguarding processes are so vital for their safety, their well-being within the decisions that they get, because we are trying to empower them voluntarily to address what the situation is and find solutions that will work. And if we're not careful about placing them in a position to allow them to make their own decisions, then it risks them choosing something that isn't right.
Absolutely. And I think that first meeting for me is so important. And I think sometimes the clients think, oh gosh, why do we have to do this? Why can't we just go straight to a joint meeting? And I go to some length to explain that we all have to want to do this and we all have to be right for that process. And that's why I want to spend time with them individually before I'll see them as a couple. But once, and hopefully, they've got through that first process with me and we've all agreed that we want to go ahead. There's lots of elements that are actually quite similar to both collaborative and mediation, in the sense that I'm working with one couple and giving them legal advice, not just information. We do have a specific agreement for the one lawyer, one couple approach, which I go through with them. So a bit like the participation agreement, sets out the terms of how we're going to work together and what we will do and what we won't do. And it flags things like, if I became aware of safeguarding issues, say for children, etc., that I have duties that override my agreements with them. I haven't thankfully had to do anything like that yet, but it's there as that sort of safeguard, I think, for everybody, the lawyer and the clients. And then, again, it's a series of meetings where we will get together around a table and I will facilitate them through financial disclosure, talking about how they're going to start a divorce process, talking about the law around financial remedy, what orders the court can make, and identifying what other expert evidence we might need. Again, pretty similar to what you'll both do in your processes. Do we need a pension on divorce expert reports? A hugely important part of a lot of the cases we deal with. And like collaborative, I'm not sure about mediation. I can bring in other people. I'm not sure whether you can to mediation or not, Dawn.
So, I do regularly need to guide them to get pension information outside of the meeting, and that might include having a report on what pension sharing might look like for them. But as a mediator, I don't get involved in the instruction of
that would go back to the
person. I mean, some mediators do it differently, but my preference is to guide them. You might have a code that would help them formulate the letter of instruction. There are systems that are offered by various people that do that, but others expect the lawyers to, the clients or their lawyers to come up with the letter of instruction, because that frames what questions are you asking. Yeah. What solutions or advice are you looking for? There is something called a pension advisory group that has helped sort of formulate our understanding around pensions, and there's a template for the instruction to a pension advisor. So I definitely sometimes need that. I've also had an accountant need to advise on business value. And actually in that setting, particularly if they are seen as a neutral, because they're recognised, we have groups of us that are collaborators, mediators. It's not just us from this firm around this table, but we have others in other practices. So we share knowledge and have people who are financial neutrals that we can reach out to. And I've had one of those come into a mediation meeting, and there's been a verbal discussion facilitated by me with the couple as to what information we're looking for them to garner from them to then come back and give an answer or a range of what options in terms of how much money is in this business, can any money be extracted from the business, what kind of income stream can it generate? Those sorts of things can be covered.
They would be similar.
I can bring people in.
Okay, so that would be similar then in a way to the work that I'm doing with the one couple, other than it would be me that would be instructing the pension on divorce expert if we needed one.
And for children work, there may need to be consultation with children.
Yes.
Which the couple can do themselves in something called indirect consultation, but that should be procured in a way that they do it together. So it's not going to create more division or dispute. But sometimes they would agree to have a child mediator come in, because that wouldn't normally be me. I'd have someone separate come in, consult the children, as long as the children are comfortable.
Like a child-inclusive mediator.
Yes. But the children may not want to disclose very much. They may not want their parents to hear their opinions, but at least consulting them can be a useful way of breaking certain impasses over problems that the parents see. It is hard to hear what your children are thinking, saying, especially when they commonly hear it as, well, they say that to this person, but that to this person. Well, they know what you want them to say, so they'll say that, won't they? It's very challenging.
Absolutely.
But there's every opportunity that we can offer, we will, to try and
make things easy for clients. Absolutely. So, I mean, from my perspective, the one lawyer, one couple process, I would say the advantages of it are it's quick. You can have legal advice in your meetings. You can work with one lawyer to do everything. And over the years, probably like both of you, I've had so many people come to me and say, we're really amicable, everything's absolutely fine, we just need someone to help us to put what we want to do into an agreement. And sometimes you get a red flag from that and think, but most of the time, if I'm being honest, it has been the case that they are really amicable, they know what they've got, and they don't want to have two lawyers, and they don't want to have the cost of that, and they just want it to be done. And I've done a number of cases over the years where I've acted for one person, and the other person hasn't actually taken any legal advice. I mean, I've told them to, obviously, but they've chosen not to, because the trust is there. There aren't any mysteries. Everybody knows what everyone's got, and it's those kind of clients that I think are perfect for this kind of work. And I think it's really important, in a way. Part of the screening process for me is to ensure that where clients are not necessarily on the same page, there's leeway within that. I mean, I wouldn't necessarily expect everyone to be as financially savvy in a relationship, but it's identifying those cases where there's a lack of trust would always be a big one for me. If there was complete lack of trust for one reason or another, then the one lawyer, one couple process, I don't personally feel would be as effective. But collaborative could be, because you've got somebody...
You've got your solicitor looking out for your best interests, making sure that, everything's going to be... You're going to understand everything. So just because you might not trust your spouse,
you trust the person that's advising you. Whereas absolutely. I'm not allowed to give positional advice at all. My advice has to be, this is what the law is. I am allowed to say, if clients have come to an agreement, I'm allowed to give it that kind of judicial overview. So I think it's important to explain, for the benefit of the audience, that just because you might like an agreement doesn't mean the court will like it. Clients find that hard.
I have a similar overview in mediation. I am allowed to say, this outcome that you're debating, you would like to perhaps be putting to the court, is one that I consider is within the range that a court would determine in this case. It is usually a range. It's not a binary, well, this is the answer, that is the answer. It's definitely not like that, because it's so nuanced as to what the couple come with and what the needs are of them, their children, to make the best call that can be made. In all the circumstances.
But so from my perspective, with one lawyer, one couple, I will have a series of meetings with them. I will take them through financial disclosure. I'll help them sort out divorce proceedings. I'll then draw up spreadsheets, etc. We'll look at how their agreement might look when we plug it into a net effect kind of calculator. And then if everything looks fine, I can draw up the court papers, the consent order that you talked about, Dawn, earlier. And I can deal with all stages, including implementation of the court order. And clients often forget about that last process. It's not just about getting your agreement, it's about making sure it's actually ordered by the court and then implemented. So the house is transferred, a pension sharing order is made. And I think that it's for me, I've found it to be a really beneficial option for clients on top of all the other options we have. But I think drawing us all together now, I would say that there isn't a one size fits all. And for me, I tend to screen out before I see clients whether I think they might be suitable for something like the one lawyer, one couple, because the minute you've seen one of them, then effectively you've potentially given quite positional advice already. So it's almost, for me, a screening on that phone call first to see if it's something they might like to consider. And if it is, then I'll say, okay, can I have a conversation with your other half and see if it's something they might like to consider. And then if it is, then I'll sit down and have the separate meetings. But I will also, probably a bit like you do in your MyAMS, Dawn, talk to them about the other options available and whether they might be better for them too.
Yes. I mean, I sometimes get calls from people, and because they know I'm a mediator but also a family lawyer, they actually don't know what they need from me. So I do have to have that kind of neutral call with them and explain the differences between me being their advisor, but still maybe recommending mediation to them that would be provided by somebody outside this organisation, or whether they would choose me as their mediator, but know that they can seek independent advice elsewhere should they need it. And it can be, you know, they're struggling with a real dilemma in their life as it is. So already you add confusion because they don't.
Yeah,
they want to be
There's
going
lots of processes to
somewhere
think about,
where they can get help, and they can feel quite anxious about gaining help from, you know, more and more people, especially if that increases the cost of that, which is why they come to one of us in whichever process is the best, for us to be their guides, and it is very much nuanced to what suits them. And you don't always see both sides of that either. If you've just got the one person coming to you, you've got to trust in whoever else they go to, which you wouldn't experience in your position, Emma. But yeah, we have to trust that what they're hearing elsewhere, we can handle that with them.
It's quite interesting because if you're doing the one lawyer, one couple, and you're doing mediation, you speak to both parties before. You go into that process. Whereas with collabs, I don't meet the other spouse until the first meeting.
It can be quite
and then
unusual first meeting, can't it? To get to know.
That's the first time I've actually you get to know the dynamics.
Yeah.
But of course, I'd always speak to the other solicitor before the
to
first
try
meeting,
and get that
and
that sense, so you're not blindsided by I wasn't expecting that. But you do come across unexpected things. That's life. You know, we're human beings at the end of the day in terms of our jobs, what we offer, and that's what we're dealing with. We're dealing with human lives. We're looking to allow them to build something in the future, even though this might be an ending for them in one sense. It's the prospect of something that can be as safe and secure for them going forwards as whatever they had originally. So.
Absolutely. I mean, kind of drawing us in at the end of our discussion, I would say for me, I always say to clients, I can pretty much, I've done this job for nearly 30 years. You've done it even longer than me. I can pretty much see.
under the bus there.
Although looking glamorous still, obviously. But I've done this job for a long time now, and in most cases, I can see how a case will resolve itself within parameters. I mean, I'm not going to say I could predict exactly where it will end. And I usually say to clients, look, you know, there's an end goal you're going to get at. It's going to be within a certain perimeter, and it's a question of how you want to get there. You know, do you want to go on the smooth motorway where you can stop for some comfort breaks and you can have a cup of tea and some lunch, or do you want to go on the really crappy, bumpy road, which will take forever and a day, and you're going to get there feeling tired and flustered? You'll get to the same place. It's just a question of how long it's going to take you and how much it's going to cost you. Yeah. And I think that if you can have these sorts of sensible discussions with clients right at the get-go, and provided there aren't any safeguarding issues, providing there aren't any serious domestic abuse issues, which we can't do much about that is what it is, then this non-court dispute resolution options, and particularly the ones that we love, mediation, collaborative, and the one law, one couple, have got to be a better option.
I love that metaphor. though I have this image of somebody in a jeep across a desert saying, "Yeah, but I want to go for court no matter what, because I just want the exhilaration of something that I don't know what the outcome will be. I think I'll win, but I don't know. You might get a flat in the desert and."
Absolutely.
You don't win.
Absolutely. Well, I think it's fair to say that all of us would recommend against the day in court unless it's absolutely necessary. And it's important to say in some cases it is absolutely necessary.
The court process, it has to be there because...
as a safeguard.
Yeah, absolutely.
Yeah. Some people just cannot make the decision.
Or
and
some
need
people
it
are so
made
unreasonable that you have no choice.
Yeah.
Those are the cases.
Dishonest.
Yeah, or dishonest, yes. Or don't want to disclose. But for those, for the majority of cases, actually, that's not the case.
No.
I think that is the exception rather than rule.
Yeah.
Then these non-court dispute resolution processes, which we
Yeah.
really champion here at Whitehead Monckton, are absolutely brilliant.
Yeah, statistically, we do definitely have
definitely do.
More consent solutions than any other court ones are. Thankfully, not quite as rare as hen's teeth, but rarer
Pretty good.
than
Sarah
this.
Dawn, thank you ever so much.
Thank you, Emma, for hosting us.
I've really enjoyed discussing that with you today.
Brilliant.